you. Okay. So I will
7:02.
turn on the recorder. Recording is on. It is 7:02. So I'm calling to order the special Board of Directors meeting. And it looks
You have a
like,
microphone? This is,
well, apparently I don't. I will have to share this with Leslie.
no, she has her own over there.
Okay. Talk to the people who set up the chairs. Okay. Looks like everybody is here tonight except Rich. Certainly, I wish him well. Okay. Adoption of agenda. We have a very short agenda. This is a special board meeting, and several of us would like to keep it short. So, are there any changes, emendations, suggestions? Okay, hearing none, then unless there's an objection, I'll rule that this agenda has been adopted by acclamation, and we move directly to property owner comments and board comments. Are there any property owner comments? And as usual, stand, name, address, location, whatever. Okay, I see no hands or movement out there, so then let's move straight to the item on the agenda. You will notice as an attachment a proposed ballot measure. This has been floated by our attorney, and before it's even introduced, I would like to say what the attorney would like to have changed. So we get that done before we even introduce it. Okay. At the end of the second paragraph, it starts out, renters and other non-members will be provided appropriate access, comma, by card, comma. He suggests we say merely at rates established by the board. He says a rate, but I think rates is better. So we just cross out the word higher.
Cross out what now?
Delete
The word higher. So it simply reads, renters and other non-members would be provided appropriate access, comma, by card, comma, at rates established by the board.
Oh, it's already there.
Okay, then can I ask, well, no, let's introduce it first, and then I'll ask if there's anyone from the petitioners group here. Would someone like to make a motion?
I make a motion that, were you motioning just to read it this time, or we're making a motion
You don't need to read it, you
accept
just introduce this to be
Okay, I make a
passed.
motion that we introduce the ballot measure for the special assessment.
Second.
Okay, it's moved and seconded. Now there's an open for discussion. Let me ask, is there anyone here who happened to be on the petitioners group? Oh. Would someone feel confident to answer a question and have you read this material here? Okay, I'm going to ask one of you guys to say, does this comport with the intent of your petition?
And please come to the podium.
Okay, yeah, that'll sound good. Spring is early, there's mosquitoes.
And
Eric.
your name and,
Robin Dieter, 77 Marigold Drive.
thank you.
So the question is, does this language accurately reflect the intent of your petition?
Yes, it does.
Okay, very good, thank you very much.
Just Judy.
So now it's open for discussion amongst the board. It's been moved and seconded, and it reflects the intent of the petitioners. Linda,
Mr. President, we have Leslie.
Linda was first, and then Leslie.
Sorry.
Okay, I'm going to start this off and be the most hated person in Sudden Valley again. I don't know that this is a legitimate special assessment measure. I know the attorney has looked at it. I look at section 19 of our bylaws, that say that annual dues, it's Section 19, Annual Dues and Assessments, and it says that dues and assessments should be used for the general purpose of promoting the recreation, health, safety, welfare, common benefit, and enjoyment of the owners, including maintenance of the association's real and personal property, all of which may be more specifically authorized from time to time by the board. Section 3 says special assessments shall be for the purpose of paying for the costs of and any loans related to capital improvements and repair and other association purposes. This special assessment doesn't fit what it says in our bylaws are allowed. State law also references special assessments tied to our reserve studies and that sort of thing. I know the attorney has looked at it. I know last year we had 2 special assessments. One was for roads, which was perfectly legitimate. It's a reserve. But you don't use special assessments for an ongoing cost. You use special assessments for something that has an ending date, and I'm concerned that maybe we did that a little bit post-haste. I don't know how Rich gets around state law or even our bylaws to say that it's okay to do that. It says that special assessments generally cover the one-time expense of a major repair or improvement, which deals with our capital assets. And it says that, special assessments should never be used in lieu of proper budgeting, and it should only be used as a vehicle to cover those unanticipated expenses or capital or deferred maintenance items not considered in the reserves for the association. And so it's limited this, and I just, it's sometimes we start reading the bylaws, and we've redone them so many times. I know the last time we had a special assessment, I had to speak to Director McRoberts, who was at that time board president, because it's changed, and the board is now, because of the rewording, we have to vote on things, and we called a quick meeting, and we voted, and that was how it was. So that's my first concern before we even get into any language. There's other things that's language in here. I'm just concerned about, is this a legitimate special, a special assessment? And really, I don't know that it should be. It could be a dues measure, certainly, but I don't think a special assessment. That's all I got to say.
Okay, thank you. Who's next?
Mr. President, Leslie?
Leslie.
Yeah, I had 2 points to make, and the first one having to be the,
Microphone, please.
thank you. The measure itself does conform to the intention of the members who did bring the petition forward, and therefore, I don't think that we need to make any substantive changes to it, because then that would violate the intention of the petitioners. The second thing is that the bylaws state that when a petition is signed by 10% of the membership, and then brought to the board, that the board is then required to hold a special general meeting. And so to refuse to accept this, to me, seems to be a violation of the bylaws.
Mr. President, Eric?
Eric.
This petition was accepted a week ago in accordance with the bylaws, as demanded by the bylaws. And so this is no time or place to refuse a petition. That's just the way that the law is written. Now, we can agree or disagree with the wording of the bylaws or the requirements of the bylaws, but this is the bylaw. Now, as far as what Director Bradley quoted of the requirements for assessments, the special assessment be for the purposes of paying the cost of and any loans related to capital improvements and repair and other association purposes. I think that this would fall into that and other association purposes category quite easily. And you could argue that, certainly, but there definitely would be an argument, because this was a petition that was legally submitted, was by our bylaws demanded to be accepted, and the ballot measure that was created simply changed, really, substantively, the language of this is a petition for the purposes of so-and-so to this is a ballot measure for the purposes of the exact same thing with very, very minor change of from $11 down to $10 and something. So that's my comment.
Thank you.
Mr. President, Sarah?
Sarah?
Okay, two comments. One, the petition was accepted at the last meeting, but it was literally given to us and we just accepted it. I mean, it wasn't like we spent hours going over it to say, is this in accordance with state law or bylaws? I mean, a petition, you could get it signed that could be completely illegal. I mean, that very well could happen. And the process of how we've done this, there was no time to say, okay, yes, this is in accordance with our bylaws, this is in accordance with state law. This is kind of the first time we're circling back to have had some time to go through this. So I think this would be the appropriate time to be bringing up concerns like what Linda is bringing up. The piece with the special assessment, all this is doing is pushing this problem down the road 5 years. Because in 5 years, we will then once again have no money to run any of these facilities that this is providing funds for. So it's a very temporary fix, which is exactly what a special assessment is not for. This is absolutely something that is part of our regular operations and should be a regular dues measure, not a special assessment. Now, I don't think us saying it should be a dues measure versus a special assessment is saying we're refusing this petition. I don't know how the rules work. I don't know if we say this should be a regular dues measure, how that works going back to, I guess, the people here representing the petition and asking them, does that change substantially the intent of your measure? Because we're still doing the same thing. We're still asking for money for the same thing. We're just saying this isn't a temporary thing. These facilities, we hope, will be here in 5 years and on, not just for 5 years. So we would be trying to have this in place to allow it to go long-term.
Mr. President, that's the only ones that have raised their hand.
Okay, then I'd like to go.
Okay.
All right. It's very clear that the bylaws are quite clear. Special assessments shall be for other association purposes. So this does not violate anything with regard to the bylaws. The language from the legislation that I heard quoted was suggestive, not mandatory. Should and ought are not mandatory language. Therefore, this, as indicated by the positive review of the lawyer with regard to this document, indicates that there is no legal or association governance problem with this material. In addition, we had short-term assessments proposed on the last AGM, and no such objection was raised to those. Not only was any objection raised to those, legal review along these lines, legal review indicated that they were completely appropriate. So whether or not this pushes the thing down the road, that is not an issue with regard to whether we accept this valid petition essentially as worded, as required by the bylaws, or whether we tinker with it outside of the requirement of the bylaws. There was one other point.
Staff input on that.
Yeah, sure, go ahead.
The board was asked and handed the petition to staff in my absence last week, I believe, and staff then vetted the signatures Staff also did the full vetting, sent the petition to our attorney, who said it was legal. We fully vetted the petition and the signatures.
Thank you. That actually reminded me of my other comment, which was, we've had a week to take a look at the petition. And the language in front of us is almost insignificant in its changes to the wording of the petition. And so there is no reason to postpone further discussion and decision this evening.
So call the question. Is there, let me back up one. If I may, is it to the board's authority now to accept the wording of the petition? Or is it the fact that the petition has been vetted, there are more than 10% of the residents on the petition, does that make it an automatic as far as the board is concerned?
That's an interpretation. The bylaws are less than absolutely clear, but as I read the bylaws in the context of our responsibility as a board of directors, we are required to, as much as absolutely possible, reflect only the intent of the petitioners, not to interject board opinion or other thinking into the process, except insofar as, Linda correctly mentioned, a petition might be illegal or improper, in which case then we would have to get back with the petitioners and go through some process that is not specified in the bylaws whatsoever in order to determine how we can, in fact, legally and properly implement the petition's intent. That's just not stated by the bylaws. But with regard to this particular document, no such process is necessary.
Well, then what about the vote by the board? Is that necessary
Yes,
to accept it?
Yes, it is necessary because this becomes a ballot measure which the board is required to submit to the community. In addition, because it is a funding measure, a short-term funding measure, and that's probably why the term special assessment was picked by the petitioners, because it is a short-term funding measure. Because it is a funding measure, as the attorney pointed out 2 years ago, the board must act to pass this before it goes to a vote.
Well, in as much as we've had no other hands raised, can we call the question?
The question has been called.
I apologize.
Yeah.
A hand was just thrust into the air.
Okay,
Vanessa.
all right, Vanessa, yes.
So it just sounds like there's a lot of confusion of what the bylaws do and don't say. I'm just curious if our attorney could come in and speak to these. I mean, when he was vetting the petition, I don't know if he was vetting the signatures, but does he, or is he aware of, Linda's concerns or some of the other concerns raised?
He is a licensed attorney in the state of Washington who's been working with us since at least 2012. Was picked by that board. He is well aware of the issues regarding petitions and SGMs, having created a memo in 2016 to which I referred earlier, and which Linda provided to the board members, at least the executive committee. I'm not sure if you sent it to the whole board.
No, I sent it.
Okay.
Yeah, it came to me when I was president, so I did send it out.
Okay, all right. So Linda sent out a copy of Rich's letter, which said essentially what I just now said, which is that the board has to initiate and vote on this because it is a funding measure. So we are required to do that. But with regard to this particular issue, as I say, given that a virtually identical set of measures appeared at the AGM and at the 2016 SGM, there is no problem that I can imagine. And in addition, Mr. Davis, I happen to know because we were supposed to meet with him this morning, except he's sick. So he cannot come at the last minute here. And I see nothing but an adverse impact on the timeline that Director Bradley put out for us if we postpone this another week. We need to vote this so that we can get it out to the printer and get it out to the community in an appropriate amount of time.
Mr. President, Eric, and then Linda, sir?
A couple of comments about where the part of the process that we are in right now. We are not in the part of the process of accepting a petition. That was accepted as required by the bylaws. And there's no misunderstanding of the bylaws. It's a very simple couple of sentences in the bylaws that requires us to accept the petition last week. And it also starts the clock on the 60-day deadline last week. That's very simple. Would you agree, Director Bradley?
Absolutely.
Yes.
Please do not address questions. to
I'm
other
sorry.
directors.
Would you agree, Mr. President?
That, don't direct questions like that in general. Let's just make your statement, make your assertion, and then we can move on.
So we have to have this as demanded by our bylaws. And it's not any further interpretation of that I can see that we need. What we're here today for is to vote on the ballot measure itself with the intent of trying to conform as completely to the intent of the petitioners. And it's not up to us to say how that would eventually be interpreted by anyone that votes on it. And so we're not here to accept this petition. That's already been done.
Mr. President, Linda.
Linda?
I guess if we're going to look at this word for word and sentence for sentence, this ballot measure that was in our packet, it's different than the petition. That sentence that you read that Rich said that we should change about renters, well, then we go back to the bylaws again about leasing, which is in, oh dear, it's like one of the last pages of the book. But it says that anyone who leases their property, and if they are a member in good standing, can transfer that privilege of use to their renters. And in this measure that's here, it says that renters will be provided appropriate access at a higher rates established by the board. But I don't know how that can be if indeed the member in good standing may assign membership privileges to the tenant.
Since that's posed as a question which I think can directly be answered, the attorney's comment, which you neglected to read into your quote, was to delete the word higher rates. It simply says rates established by the board. So if a lessor is, if a lessee is, has been transferred rights by the lessor, then they will probably, under our bylaws, be able to get a member rate. If that hasn't happened, such as the case almost certainly for renters and probably most of the time for lessees as well, then that'll be at a higher rate.
But in theory.
Probably. It should be at a rate set by the board.
Okay.
A rate. So delete the word higher, and we don't even need to think about that tonight.
It's just you're separating.
Okay,
rent-
Mr. President, then, inasmuch as that discussion has been played out,
Just staff input. We have owners who have submitted letters giving their tenants their authority. And in that case, that tenant becomes the fully privileged member. This would not apply. If we got a letter from the owner transferring that authority, and we have done that.
Okay, we have another hand.
yes, sir, I see that, David.
Yeah, and it's the only, right? Because whenever I've rented, I had the choice of.
Okay, that has nothing to do with
Oh,
He's
just
he's
addressing
clarifying the
this
point, but that has been clarified. That's
Right,
the
it
owner
just
does
needs to
that.
be, it's just only, it's one or the other, you can't have both.
That's correct.
I mean, I'm just clarifying that.
That is correct.
Going down the road again. Leslie?
Yeah,
sir.
this is an implementation issue, which I don't believe is appropriate to discuss at this time, whether or not we're going to approve this measure.
That's a fair comment. Okay?
Yes, then I would like to call the question, sir.
Okay, unless there is an objection, the question is called. All in favor of this petition, which has turned into a ballot measure now, so it's a petitioned ballot measure. All in favor of the wording as modified by the attorney, please indicate. Have 1, 2, 3, 4, 5, 6. All opposed? 1, 2. That measure passes. It will immediately go to N&E, and we will get it
Bless you.
out. Thank you. Okay. Wow, I didn't finish my coat. Okay, so we've already set the date of the SGM. Somebody remind me? I believe that is
April 21.
April 21. So N&E will need to get this to the printer right away, and we need to get this out. I will just make a general board request to, if anyone thinks this needs further explanatory language added to it, or if it's sufficient in and of itself. I don't see anybody making any comments, so my response is that as far as N&E is concerned, no further explanatory language is necessary.
Use your microphone, please.
Oh, I'm sorry. I'll repeat that. Since no one indicated that they felt that further explanatory language is necessary, we'll just simply mail this ballot measure out with no additional explanatory language. It's clear in and of itself.
Mr. President, Carol H.
I just think that there needs to be a certain format that's used, and I think that Linda has it from measures before. I mean, whether it's going to fail or not, and what the vote percentage is, and that sort of thing. I think the measure itself, yes, I think is fine as is, but it just needs to have the proper formatting to explain to people how to vote, or how
It
the process
is, because
goes.
it's a funding measure, another 60% vote.
Yep.
Yes, ma'am.
In the one that was proposed at the AGM, we had a chart that told about what are the dues going to be for developing vacant lots. There was that little chart there. I don't know, do we provide that? Because otherwise, you've got a real small, as far as the ballot itself, all of this explanation can go in there, but the ballot's not going to say that whole explanation. The ballot itself will look very much like the one for the AGM, which said, shall SVCA impose a 5-year special assessment of $10.48 per month per developed lot and $7.36 per month per vacant lot, with an annual 3% inflation escalation for the sole purpose of funding the maintenance and operation of the community center, main pool, adult pool, and gym, as well as parks and trails.
My understanding is that staff has already prepared a table that would give the numbers of what the impact is on everyone with regard to the dollars, so that can be provided to you by staff. And in terms of throwing a bit of language together, I think you and staff can handle that. My opinion, this is purely my opinion, in days long ago, the ballots used to print everything in full. And it was in 2013, 2014, we stopped doing that because there was too much to fit on a ballot. This is short enough it could all fit on one ballot. So It is hypothetically possible that you don't need to have that short form language. Otherwise, you can simply say, if you need short form language, you don't need to go into the detail that you just quoted from the last AGM. You could simply say, are you in favor or opposed to the petitioned ballot measure as stated in the accompanying material?
Well, usually there's the ballot, the explanation, then any additional stuff, and that's what
And there
I
isn't
stick with
anything,
doing.
for here, there is only this plus a table that shows the impact on dues. So there isn't really much.
Mr. President, Leslie?
Yes, as far as putting in the table of the dues increase is concerned, I don't see that it would be necessary to put in any more than if this passes, these are what your dues will be for the remainder of 2018. Because you can only project what the future costs are going to be. You know what the cost of this special assessment is going to be, but you don't know what the dues are going to be, so you cannot give totals past the end of 2018.
Oh, absolutely, and I didn't take Ms. Bradley's suggestion to be for any year other than this year.
I'm not, then, I guess I don't see the difference in the special assessment from the AGM where we did project out, because you have dues numbers. The other thing I need from staff that I'd like to bring up before I forget it, we should be able to tell people how many developed lot owners and how many vacant lot owners there are. There's some, because it applies to both, and usually it tells what percentage we're going to collect at. And I'm usually that information, going back to the SGM, was provided before.
Okay, well, then I tell you what, please be so kind as to give staff a copy of what the ballot looked like at the AGM with regard to those things, and I'll work with them to make sure that it gets provided to you.
Oh, that works for me just fine.
Okay.
I'm just saying it's
Mr. President,
mostly it's in the
Carol?
booklet.
I'm done. I just wanted to say this is not where we want to talk about the process.
Right.
This should be
Thank
worked
you.
out, I think, between Linda's staff and you.
Thank you.
Okay. All
Property
right,
owner comments.
the single agenda item has been addressed, and now we come back to property owner comments and board response. I believe Ken had a property owner comment.
My name is Dr. Ken Murray, 30 Creekside Lane. I didn't know the procedure. It's been a while with Robert's Rules of Order, so I apologize. I was hoping to make this comment prior to the vote, only to say to the board that I believe the community and many members of the community see this as a very, very important item agenda that needs to be dealt with, that has lost in many, many ways in the past. And what I was hoping to say to the board is I was hoping that the vote would have been unanimous in the way of accepting the vote, to show our community members that the whole board is behind this. So even though the numbers have been taken, I would like to encourage those board members who did not vote in favor of the motion to let the community know that this is an important growth in our community and to be able to help yield its success. Thank you.
Thank you. Are there any other property owner comments? Yes, ma'am.
Elizabeth Huthard, 8 Westbrook Court. My husband and I moved here in 2000. I have voted for every dues increase since then. I have signed every petition. I have volunteered. And because there's this constant resistance to spending very little money, this community is dying. The stench of debt is all over Sudden Valley. Things have closed down and closed down and closed down. And if people don't start moving towards reviving the community, it will be dead. You mentioned I'm not supposed to indicate anyway. It was mentioned that kicking down the road, in 5 years, we'll have the same problem. In 5 years, some of us are going to be dead. So let's deal with it now. Let's get some money going and do things. Thank you.
Thank you, ma'am. Are there any other homeowner comments? Yes, sir.
Good evening, Rob Gibbs, 14 Far Summit Place. I just want to speak to that. I think that the rec task force still needs to continue to do the work, the good work that they've been doing. A lot of really good work's been done there. This opportunity for us to vote on at a special general meeting on this measure is good, and it's good that that's moving forward. But we don't know what's going to happen. And there were some questions, really good dialogue the other night. So I'm hoping that that rec task force continues to move forward. If I recall, something would need to take place the day after the vote. So there was a little change in leadership, and I will be happy to join that rec task force. And I really hope that other people who were involved, who were there, will continue to do so. We need to have a good transition if there's some change there. It'd be very difficult to do that on our own, and so Mike and directors, let me know when that next meeting will occur, because I would be happy to join you and help. I don't want to see that die. We don't know what's going to happen. It's not option A or option B to me. What it's really about to me is I don't want to see us lose any more of our, I can't even pronounce the word, assets, amenities, or whatever. I don't want to see a pool filled in. I don't want to see things falling apart. Thank you.
Thank you, sir. I will respond a bit. It is the intention of Mike and myself to make sure that the rec task force keeps working, and we are not going to wait until the SGM. I'm not sure exactly when our first meeting will be, but an email will go out to the existing members, and the email address, which I would urge you to write to so that you can let us know how to get you onto the task force, is Rec Task Force, RECTASKFORCE, all one word, Rec Task Force at SuddenValley.com. So just write the task force and say you want to be on it. Now, the downside to that is everybody on the task force will see that you volunteered, but I guess you're going to see them all anyway.
Right.
And to repeat, we will be sending an invitation out to the existing members of the task force indicating that meetings will go forward. As you said, we do not know the outcome of the SGM, number one. And number two, there's a lot more to the issues here than just what is covered in this ballot measure. So thank you for bringing that up.
That hard work that team did was not a waste of time. I think it was good, hard work, and I think continued work is not a waste of time.
I certainly agree.
Yeah, I'm a member of the communications committee, so I'm already vetted. I'll send an email and move forward.
Thank you. Any other homeowner comments? Okay, seeing no other homeowner comments, is there a board or staff comment? I see a staff.
This is just an announcement. We were given very last minute notice from Puget Sound Energy that they'll be doing work in Gate 3 tomorrow. We have put it out on our website, also an e-blast, stating that Puget Sound Energy will be doing work on Sudden Valley Drive that will involve cones, traffic disruption, and electrical power outage. So that will involve up to 70 members of the community, and they have not been able to identify who. And so we're encouraging members to contact Puget Sound Energy directly.
When the accident occurred, I think my home suffered a brief double power outage. So anyone who suffered that probably will be impacted tomorrow.
They will likely be impacted, but unfortunately, PSC has not been able to give us that information, only that they will be doing work tomorrow. and that there will be flaggers and some traffic disruption, and some members will experience a power outage. But they are the comm center, and so PSC is whom members should be contacting.
Right, and Carol asked what accident, so,
I'm not familiar with an
It's all right,
accident.
we had
It's a-
power outage, I'll find out.
yeah,
Okay.
my understanding is
It's
that
not,
there
it's
was,
not a board issue, I'll find out.
Okay, but it's
Is
just
that
an
there was an
announcement for
accident,
the community, since we are streaming live.
okay, thank you.
Mr. President, move to adjourn.
Okay,
Second.
all right then, if there's no further business, my gosh, look at this, it's 7:42.
I don't think it's going as far up as you from the email that we